Hello everybody, and thank you for joining. Those of you that are just still joining us, we'll just give you a little while to just settle in. I'll start the webinar just after 1 o'clock. Hello everyone, those of you that are still joining, thank you for joining us today. Make yourselves comfortable and we'll get started in just a moment. Right, I think it's time to make a start. Thank you everyone that's joined us today. We're going to be talking today about TUPE and what you need to know about this if you're a social care business. Next slide, please, Amber. So you've joined a webinar today with QCS, Quality Compliance Systems. Some of you will be our customers and some of you won't be our existing customers, but welcome to you all. Just wanted to let you know that QCS is a compliance management system that enables you to focus on what really matters the most, and that's delivering great quality care. So we have policies and procedures and compliance toolkits all shaped to your business needs and all informed by our team of care specialists. And most importantly, everything is up to date 24/7 every day of the week. Our content is up to date and available to you on a mobile handheld app, so it's there at the point of care. So today we're going to be talking about a very specific topic. Next slide, please. And before I introduce our experts for today, just want to let you know that the webinar is being recorded, so you will receive a recording of the webinar. You'll also receive a copy of the slides. We also have the opportunity to ask questions at the end. You've already asked us a number of questions. Thank you very much for sending those in advance of the webinar. We will answer those questions at the end of the webinar, and you also have the opportunity in the webinar to ask questions in the chat. If anything springs to mind while our experts are talking, you can pop that in the chat. If we don't have time at the end, we'll answer your questions after the webinar. So without further ado, I would like to introduce you to our partners from After Athena, Chris King and Olivia Riley. Can we go on to the next slide, please, Amber?
So, hi everyone. Thank you for joining us today, and for Lindsay for introducing us to you. Chris and I have been invited to speak to you today about TUPE, and some of you will know what that means, and particularly in relation to employees and the buying and selling of businesses or the changing of contracts. You might even have experience of dealing with a TUPE transaction. However, for some of you, you might not have any idea what TUPE is. You might have just heard of the term and not really understand what it means in practice. Either way, that's all right. We're here to set out a basic understanding of TUPE in the social care setting for you. And so, as you can see from the slide, we'll be covering what constitutes a TUPE transfer, service provision changes or SPCs, the effect of TUPE on employers and employees when businesses are being bought and sold or contracts changing hands, the obligations under TUPE for employers involved in transactions such as TUPE, and then finally we'll cover off some top tips and a bit of a summary of some key points that we think it's worth taking away with you. Can we go into the next slide, please? So I know that some of you might be thinking, what is TUPE? What's she talking about? Well, TUPE is the abbreviated name for the Transfer of Undertakings, Protection of Employment Regulations, and it's a piece of legislation designed to protect employees if the business in which they are employed changes hands or where a contract they are providing services under is moved to another contractor. The practical effect of the TUPE regulations is to shift employees and all of their associated liabilities from their existing employer to a new employer along with their work. Now, even for lawyers, TUPE can be a daunting topic, but it doesn't need to be. And by the end of this webinar, hopefully we'll have set aside any of those fears, and you'll have a good understanding of what TUPE means. Next slide, please. So let's start at the beginning. In order for TUPE to apply, there must be a relevant transfer. Well, what's a relevant transfer? So TUPE sets out two types of scenarios, as you can see here on the slide. Firstly, a standard transfer, which is a transfer of an undertaking or business or part of one, situated immediately before the transfer in the UK to another person, where there is a transfer of an economic entity that retains its identity. And then secondly, we have service provision changes, or SPCs. And you can see on the slide there that this is where a client engages a contractor to do work on its behalf, so outsourcing, reassigns a contract, which is a change of contractor situation, or bringing the work in-house, insourcing. And now in simple terms, TUPE will apply where there is the purchase of a business and its assets, or where a contract for the supply of services is won or lost and the staff allocated to the contract remain the same. It's important to flag, that some transfers may be both a standard transfer and an SPC, but we don't need to worry too much about that during this webinar, because we're going to be focusing on SPCs, or service provision changes, as they're most likely to apply in the social care setting, particularly when contracts are being tendered for. Next slide, please. So as you saw on the previous slide, there are three types of situations which can trigger TUPE under the service provision change branch. There's outsourcing, which is where a contractor is appointed to carry out activities on behalf of a client rather than the client performing the activities themselves. Change of contractor, and the client in need of the services remains the same, but the activities move from one contractor to another. And then finally, insourcing, and the contractor stops carrying out the activities on behalf of the client, and the client brings them back in-house and does them for themselves again. As with any type of legal concept that's quite tricky, we thought that it might help to set out an example for you, as that's the best way to make it relatable and understandable. And that's what we've done here on the slide for you. So a company, Care Limited, employs its own cleaning team to look after the cleaning of its facilities, which we've defined as the cleaning function. It decides to outsource its cleaning function to Clean Incorporated, and this will be classed as an outsourcing situation. So Care Limited isn't doing it for themselves anymore, they've got someone else to pick up that work for them, Clean Incorporated. But after 2 years, and not happy with the service provided by Clean Incorporated, Care Limited decided to transfer the cleaning function to another service provider, which we've called Sparkle Limited, and this will be classed as a change of contractor. It's just moving from one contractor to another. And then finally, after a further year, Care Limited realised that they would just be best placed to bring the work back in-house and to do it for themselves. And so they end their contract with Sparkle Limited, and that would trigger an SPC by insourcing. So hopefully you'll now have a clear idea of the three types of service provision change scenarios, which will be classed as a relevant transfer and therefore may trigger TUPE. Next slide, please. However, even if one of those three scenarios exists, the following conditions must also be satisfied for TUPE to apply. And this is where we can see, as it shows on the slide there, immediately before the service provision change, there is an organised grouping of employees in Great Britain which has as its main purpose the carrying out of the activities on behalf of the client. And I'll come back to this again in a moment. Secondly, the client intends that the activities will, following the service provision change, be carried out by the contractor, other than in connection with a single specific event or task of a short-term duration. So the change must be more than a one-off. It needs to be the plan that the contractor will be carrying out these services long-term. And then thirdly, the activities concerned are not wholly or mainly for the supply of goods for the client's use. Now, given that we are talking to people within the care sector today, it's clearly going to be care services that we're talking about and which will be involved, so we don't need to worry too much about goods in this scenario. However, the activities or services that are transferred must be fundamentally the same before and after the transfer. Now, going back to what is classed as an organised grouping of employees as set out under bullet point 1 there, well, it's a legal concept which will require proper analysis at the time of the transaction, looking specifically at the facts of the deal that you're involved in. And of course, sometimes that will be quite straightforward. For example, where you have a contract for 2 cleaners to perform cleaning services for your business, and you're going to be asking another contractor to take over that work, and that will still be carried out by 2 cleaners. And so you can see in that situation, it's likely to be clear that those 2 employees are classed as an organised grouping for the purposes of TUPE. However, sometimes it's just not that straightforward. For example, where you have a number of different contractors providing perhaps maintenance and cleaning services to your business, and cleaning is just a really small part of that. Also, the employees that carry out the cleaning work, they perhaps do some maintenance work as well. And in these situations, you can see that it might be hard to identify whether there is an organised grouping of employees carrying out the activities. And it can also be hard to identify their main purpose and whether or not the activities will be fundamentally the same before and after the transfer. So it is always going to require a legal analysis of the situation to determine whether TUPE applies or not. And as you can see, it can be quite complex. But TUPE will likely be a consideration in virtually all service provision changes, such as outsourcing and insourcing. And if you think that a transaction that you're involved in might be covered by TUPE, we'd really recommend that you take specialist advice from legal professionals. Next slide, please. And so if TUPE does apply, well, what does that mean? What's the effect? Well, the new contractor will step into the shoes of the old contractor, and the employees assigned to the service contract have the right to automatically transfer to the new contractor on their existing terms and conditions of employment, and with all of their existing rights and liabilities intact. Although there are special provisions dealing with pensions under occupational pension schemes. So going back to the example that we gave on a couple of slides ago, when Sparkle Limited takes over the cleaning function from Clean Incorporated, Sparkle will not only take over the contract for cleaning services, but they'll also inherit all of the employees of Clean Incorporated assigned to the cleaning function on their existing terms of employment. And so what would transfer with the employees? So that can be, what would be, salary, holiday pay, medical and permanent health insurance. Maybe they have a company car, commission and bonus schemes, and maybe enhanced redundancy schemes as well. So if Clean Incorporated had failed to pay its employees their wages for the past few weeks, Sparkle Limited would pick up that liability to pay the employees their unpaid wages under TUPE. So you can see that Sparkle Limited will step into the shoes of Clean Incorporated and pick up that responsibility to pay wages. However, it's important to know that employees can refuse to transfer or object, as we often refer to it. But depending on the circumstances of the case, they could lose valuable rights by doing that. And if they do object, then their employment would usually come to an end at the point of the transfer. Moving on to the next point on there then, so it says, finally, any dismissals will be automatically unfair where the sole or principal reason for the dismissal is the transfer, unless there is an economic, technical or organisational reason entailing a change in the workforce, and we tend to refer to these as ETO reasons. And in straightforward terms, this means that there are certain circumstances where a dismissal is permitted due to the transfer. However, again, as with any legal concept like this, whether there is an ETO reason is a legal question, and we'd really recommend that you take specialist legal advice if you're looking at making any dismissal, as part of the transaction which involves TUPE. This is because the scope of ETO reasons are narrow, and this will just help to ensure that as many employees as possible keep their roles, and that's the public policy reason for having those ETO reasons. Okay, can we move on to the next slide, please? So we've already covered off the types of situations where an SPC will arise. However, as we've mentioned, TUPE will most likely be relevant to businesses in the care sector when tendering for care packages. So to quickly summarise, what is a tender? Well, businesses are invited to bid for contracts from public or private sector organisations which need specific skills for a project or goods and services on an ongoing basis, and these are common in the context of care packages. A party, which is generally the local authority, will put out a tender announcement inviting interested parties to submit bids for packages of care, and these could be classed as an outsourcing or change of contractor scenario. Interested businesses will then submit a bid to provide the services and complete a tender documentation. And unless it's an entirely new package of care, the contractor will likely need to confirm how they intend to deal with their obligations under TUPE. And finally, there is usually or occasionally a separate commercial agreement for the contractor to sign if they are successful, including enhanced TUPE obligations on entry and exit and restrictions on what the contractor can do with any employees within a certain period before a TUPE transfer. And that's to avoid the outgoing contractor from perhaps increasing the employees' wages and forcing that responsibility to be placed on the new contractor. So I'll now hand over to Chris to explain about the obligations that employers have under TUPE.
Can we have the next slide, please, Amber? Thank you. Thanks, Liv. So moving on to the TUPE obligations, obviously, as Liv said, TUPE is a complicated area. We've tried to keep it as simple as we can. We're going to repeat throughout, and you'll probably get sick of it by the end. But please do seek some guidance and advice if you are engaged in any kind of TUPE scenario, because you'll see later the potential financial implications for getting it wrong can be very high. Next slide, please. So generally, the first stage will be for a transferor. Then we've put a little key on the slide there when we're talking about transferor and transferee. The transferor is the outgoing employer. The transferee is the incoming employer. It will be, the first stage will be for the transferor to provide what's called employee liability information, or ELI, to the transferee. And in a tender scenario, as Liv said previously, this will often be provided by the bidder at the point of the bid, potentially as an anonymous list as part of the initial tender documentation, and then released to the transferee once the bid is then successful. And as you'll see from the slide, the ELI that the transferor is obliged to provide to the transferee is really quite minimal. When you look into it in any great detail, it only gives a high level overview of the basic terms of employment. It should include things like job titles, pay, hours, holiday, pensions, other benefits, start dates, length of notice, place of work, etc. But it's not really enough detail to determine what are real liabilities, and even whether some employees may or may not transfer. We would always recommend, if at all possible, sending a separate, more detailed due diligence questionnaire, because it just helps you dig more deeper into the potential liabilities and get more information to establish exactly what you're dealing with. The incoming employer then needs to have an understanding of what is and what isn't contractual in relation to the employees. This is obviously important, as Liv said previously. It's difficult to change an employee's terms and conditions when they've transferred under a TUPE transfer. It is obviously practically difficult with the service provision change, where the outgoing provider has often lost the contract and wants to get rid of as many staff as possible, and isn't necessarily minded to help out the incoming provider. Sometimes the tender process can help with this, because there might be an overlying master contract between the client, who is obviously the one tendering for the services, and the transferor, which requires the transferor contractually to provide more information than the basic ELI. Sometimes that happens, often it doesn't. I've sometimes seen TUPE provisions in such contracts confirm that the transferor must comply with all reasonable requests for information from the transferee. However, as I say, it tends to be the exception rather than the rule, and often a transferee will just have to make do with the ELI, as there's no obligation on the transferor to provide anything more than that. This is often an area of most conflict during the TUPE process, as the transferor wants to ensure that it doesn't get left with any employees that were doing work on the contract that they've lost, and the transferee will want to ensure that the transferor is not trying to effectively dump employees on them who are not eligible to transfer. Assessing eligibility to transfer is outside the scope of the webinar, but there's no hard and fast rule, and the law around what employees are part of the organised grouping and are assigned for the purposes of the transfer is developed and based on case law and is complex. Often it will be obvious that an employee is part of an organised grouping to transfer, as the job that they do will solely be performed under the relevant contract being transferred, but sometimes, as we said previously, it may not be the case. The issues come when an employee does some work under the contract to be transferred, but may do other work across the transferor's business. And similar issues arise when an employee does most of their work on the contract being transferred, but they just happen to have ended up with that being their role rather than being organised for that principal purpose as TUPE requires. Through risk sounding like a broken record, as I say, this is why we recommend you get legal advice when going through a TUPE process, as it requires that specific legal analysis of who is and isn't in scope to transfer. Next slide, please. So the next stage after the transferor has provided the ELI or it's been released to the transferee via the tender process is for both parties to decide whether they propose any measures which may impact any affected employees. In this context, measures means any changes at all which affect any of the affected employees. And affected employees isn't just the transferring employees under the contract, it's any employees of either and both the transferor and the transferee who may be affected by the transfer. As an example, losing a chunk of staff from the transferor might mean that there's a separate support team who's not necessarily in scope to transfer, but provides quite a lot of support to that team, perhaps from a HR, financial, administrative perspective. And because that team is now transferred to the transferee, there may be less work within that team, and therefore you may be facing a redundancy situation within the transferor, despite the fact that they're not part of the transferring employees. Similarly, a transfer of the transferring staff to the transferee might mean that the transferee is overstaffed in certain areas and they need to reorganise their existing staff teams to take account of that increased work. And all of these staff should be included in the information and consultation exercise that each party does. The obligation on each is if relevant, is to inform appropriate representatives of the affected employees of the transfer, and they must consult on any proposed measures. Where we're talking about those employees who are not transferring but are otherwise affected by the transfer, both the transferee and the transferor will know what the proposed measures are. However, a transferee may also be proposing to take measures which affect the transferring employees and will take effect after the transfer has happened. The obligation is to ensure that the information and consultation exercise takes place before the transfer, however, and therefore obviously before the transferring employees have become employees of the transferee. The transferor will almost without fail not allow a transferee access to the transferring employees prior to the transfer for the purpose of carrying out this information and consultation exercise. So the obligation will be on the transferor to inform and consult with the transferring employees based on the transferee's proposed measures, and it's for this purpose that the transferee provides the measures letter and will send it to the transferor for the purpose of setting out what measures it will propose, and the transferor will then inform and consult on those measures. So whilst the general rule is that the liabilities of the transferor in relation to the transferring employees will transfer to the transferee under TUPE, the tribunal can make both the transferor and the transferee jointly and severally liable for any failures to inform and consult with the affected employees. So it's therefore in both parties' interest that the obligation is satisfied, as the potential liability is 13 weeks gross pay per affected employee. So in a transfer of multiple employees, that could be a significant sum. In relation to appropriate representatives, if the employers do not recognise a union and they don't have an existing employee representative body, they can consult with, they can then carry out an election process to elect employee representatives and then consult with them. The election process doesn't have to be complex. It can be a simple ballot. People can put their names forward and then you allow the employees to vote on them, but it can take a little bit of time to get through that process. So long as it's a fair and reasonable process, that's the only obligation of the employer to facilitate that. TUPE does allow consultation directly with the affected employees where the employer has fewer than 10 employees, where it's classed as a micro business. This is not where the transferring employees number fewer than 10, but where the employer in total has fewer than 10 employees. There is an ongoing consultation at the moment to increase that number to 50 employees and to allow direct consultation with affected employees if the total number of affected employees is less than 10, but that's not currently the law. Practically, often employers will choose to directly consult with affected employees anyway, regardless of being a technical breach of TUPE. Next slide, please. So, how does the consultation process work in practice? First of all, as I've already said, the transferee is required to provide the transferor with information on any proposed measures to allow the transferor to comply with its duty to inform and consult. The definition of measures is very wide and encompasses any changes at all. So unless the transferee is taking the employees wholesale, which to be honest is very rare, there will be some consultation involved in the TUPE transfer. The transferee will first need to consider the content of the ELI that's been provided by the transferor and will determine based on that what changes it will need to make as a result of the transfer. This must always be bearing in mind that the transferring employees are entitled to transfer on their existing terms and conditions of employment as they were on immediately prior to the transfer. Often the measures will simply be administrative changes, which are arguably changes already permitted by the transferring employee's contract of employment. So some common ones are the adoption of the transferee's non-contractual policies and procedures, change to the transferee's pension provider, or a change in pay date. Generally, these are matters which are fairly easy to get agreed with the transferring employees as part of the information and consultation exercise. What a transferee should not be proposing as a measure is the harmonisation of employment terms of the transferring employees to what the transferee staff benefit from, or the wholesale adoption of the transferee's contracts of employment. Such changes are almost always going to be void under TUPE, and it can lead to transferring employees resigning, and if they have the required service, bringing a claim for constructive unfair dismissal. Similarly, the employees may also choose to object to the transfer on the basis that the changes proposed by the transferee are substantial changes to the material detriment, which is the wording under Regulation 4.9 of TUPE, and both of these claims may result in a liability for the transferee. Next slide, please. So, assuming that the transferee has sent sensible measures to the transferor should then inform and consult with the appropriate representatives, which involves exploring certain details of the transfer altogether, including the fact that it's to take place, the date or proposed date of the transfer and the reasons for it, the legal, economic and social implications of the transfer for any affected employees, and the measures which they envisage the transferee will take in relation to any affected employees who become the employees of the transfer after the transfer, or if they envisage that no measures will be taken, that fact. As I say, it's very rare that there are no measures taken in a TUPE transfer and the only obligation is to inform. Generally speaking, you will almost always be doing some sort of consultation. There's no set timetable for consultation. It must be in good time before the transfer, and the larger the transaction, the more staff affected, the longer the timetable is obviously going to need to be practically. Next slide, please. So the transferee must also inform about the transfer and consult with its affected employees about any proposed measures. The transferee's duty to inform employees applies only to its own employees who will be affected by the transfer. It doesn't have to provide information directly to the employees who will transfer to the transferor. So that's the point that we were discussing before, and that's the purpose of the measures letter. It's not the transferee that informs and consults the transferring employees. It's the transferor based on the transferee's measures letter. However, obviously practically it can sometimes be helpful for the transferee to get involved in the transferor's information and consultation exercise to the extent that it relates to the transferring employees. The transferee is obviously the one who knows the most about the measures that they're proposing, and they can provide more detail and answer the appropriate representatives' questions more easily than the transferor, who may not have all the information that they need to. This obviously relies on the transferor and the transferee being willing to work together, and on the transferor being willing to allow the transferee access to their employees prior to the transfer, which can cause some issues. I've seen on occasion where a joint approach has been agreed, and the transferee has used it as an opportunity to effectively quiz the transferring employees about what they actually do on a day-to-day basis, as part of a reason to object to their transfer because they say they're not in scope to transfer under TUPE. And it also relies on the transferor trusting the transferee to get the messaging right. Next slide, please. So in terms of the purpose of consultation, consultation should be with a view to seeking agreement on the measures envisaged, looking at and talking about the issues, genuine sharing of views, solving problems, finding solutions, making sure that the employee representatives have an opportunity to influence the decisions and how things are implemented, and proper engagement. It's not something that you can pay lip service to. It has to be meaningful. And a failure to consult will obviously, as we said previously, lead to a potential liability of 13 weeks gross pay per affected employee. Obviously, during a TUPE process, the employees are likely to be concerned about their jobs and their change of employers, and therefore this is why TUPE requires the obligation to consult to be more than simply giving lip service to the appropriate representatives. It must be with a view to seeking their agreement to the relevant measures. So the parties must negotiate in good faith in relation to all the measures that it intends to take in relation to the transfer. Next slide, please. So in summary, this is just a brief summary slide, which I think is quite a useful snapshot of what we discussed over the previous slide. So to summarise, it's the transferor's obligation to provide the transferee with the ELI, which might be done through the tender process if it involves a tender. It's the transferor's obligation to inform appropriate representatives about the transfer, and where there are measures, consult with the appropriate representatives. For the transferee, it's their obligation to provide information to the transferor on any measures, to inform their appropriate representatives about the transfer, and to consult with their appropriate representatives in relation to any measures they are proposing in relation to that. Next slide, please. So in practice, generally speaking, a tender process will be preceded by an announcement from the potential client that they intend to put the services they require out to tender. Excuse me. This may be in one of two circumstances that Liv has already mentioned. They may be doing what we call a first outsourcing or a first generation outsourcing of some services that the clients previously provided themselves. Or it may be that they're looking to change that provider. It may even be the case that because of certain procurement requirements or regulatory requirements that they have, the client is required to go out to the market to retender after a certain period of time, and the existing provider is part of the bidders who are bidding to retain the contract. Usually the first part of the process will be for the client to send out a tender pack to all the interested bidders, and part of that tender pack will require any bidders to outline how they intend to staff the contract and satisfy the contractual obligations of the service to be provided. Similarly, if the contract is already being performed by an existing provider, or the client is outsourcing and already has an organised grouping of employees which provide the services, the existing provider or the client will pull together the ELI as part of the initial stage. As I said previously, the bidders may then have access to an anonymised version of the ELI in order to have more information to submit their bid. If a bid is successful, they should then receive the full ELI unanonymised, and they should then be able to pull their measures letter together to send to the transferor. If the transferor is separate to the client, it may be the case that any information requests need to be submitted via the client, unless the client is happy for the transferor and transferee to have direct contact. As we mentioned earlier, if there is an existing provider who has lost the retendering and becomes the transferor, they aren't necessarily going to be happy about the current situation, having lost the contract, and it may be difficult to get the necessary information. However, there may be existing terms between the client and the transferor which govern how the transferor must conduct itself with the transferee, and often these go further than providing the basic ELI. If a transferee, it's therefore important that we see any TUPE terms between the transferor and the client to see if there's any contractual obligations we can rely on to force them to provide any additional information. And if a transferor, it's important we understand what additional contractual obligations we may be under and how these interact with our existing obligations under TUPE. As said previously, often there will not be any contractual documentation that can be relied upon and no prospect of having some drafted to clearly set out what each party's obligations are. Effectively, at that point, both transferor and transferee are reliant on the good faith of each other and a willingness to comply with their legal obligations. Again, this is where having legal advice to support can really help. Next slide, please. So again, this is just a summary slide setting out what we've already discussed. So in summary, the successful bidder needs to assess the ELI and any other information they're able to get from the outgoing contractor and determine whether there are any measures that he needs to take. The successful bidder should then communicate the measures to the outgoing contractor, and then it's the outgoing provider's obligation to inform and consult on the measures with its own affected employees. And I'll hand back to Liv with some top TUPE tips.
Thanks, Chris. So before we finish, we just wanted to quickly run through some of the key top tips and takeaways for you at the end of this webinar. So firstly, the effect of TUPE can mean that if you are taking on a contract, you could inherit costly terms of employment. So be aware that when TUPE involves outgoing public sector employees, there will be additional obligations in place to protect their pension schemes. Secondly, there's also the risk of an automatic unfair dismissal claim where an employee is dismissed because of the transfer if they have more than 2 years service, and the awards that they may receive from a tribunal if they are successful can be significant. They would be entitled to a basic award, which is equivalent to a statutory redundancy type payment, and potentially an additional award, which is the lower of their annual gross salary, or £105,707. And that figure changes every year in April. So as I explained earlier, if you are looking at dismissing any employees as part of a TUPE transaction, please do take legal advice, as whether there is an ETO reason which may permit a dismissal is a legal question, and the circumstances are narrow where an ETO reason might apply. So thirdly then, any post-transfer changes that you are looking to make to an employee's terms and conditions would be void or unenforceable. So again, if you are wanting to make any changes as part of the transfer, please take legal advice, as if not, you could create the risk of a claim for unlawful deductions from wages, breaches of contract and/or constructive automatic unfair dismissal. And as you can see from the slide, during the transaction, you need to provide the employee liability information and keep it up to date, if anything should change as the process goes through. If you don't, there is a risk of a minimum liability of £500 per employee, and that can easily be avoided just by keeping things updated. Finally, as Chris covered earlier, following through with the information and consultation process is vital, as employees can bring claims for a protective award for a failure to inform and consult, and they could be awarded up to 13 weeks gross pay each. And I know we've said that about 3 times, but it's such a large sum that, you know, it's worth hammering that home to you. So it can be a costly failure, and again, one that could hopefully easily have been avoided. So hopefully you feel that this webinar has been useful, as we appreciate that we've covered a lot and it is a bit of a complex topic. Of course, after the webinar, you will have access to the slides and this recording to look back on. And we've also pulled together a couple of flowcharts for you, which you'll be able to have access to, which sets out some of the process and hopefully simplifies things for you to have a look at. And I think that's everything. So time to pass back to Lindsay for some questions.
Exactly. There we are. Meaning your loss. Now it's time to answer the questions.
The audio's gone a little bit funny, Lindsay.
Can you hear me now?
Not really. You're buzzing a little bit.
We do
Let me plug this in. I'll put my headphones on and see if that's better. Is that any better? Any better?
I think it was a little bit.
It's a little bit better.
Yeah.
A little bit better. Okay. I will post one of our first questions for you, which was came in on the questions that were sent in advance of the webinar. If someone has resigned, it's covering it as we have better pay and bonus.
Really sorry, Lindsay. It's gone really bad again. I know we've got some of the questions in front of us, so should we just answer these questions?
Yeah.
Would that be okay? So
absolutely
one of the
fine.
questions that we had through. Oh, sorry. One of the questions that we had through was if someone's resigned from the previous company, as we have better pay and bonuses, does TUPE still come into effect? So if the employee was in scope under TUPE to transfer us, but they resigned before the transfer took place, then to come and work for us separately, then they're not assigned to the organised grouping at the point of transfer, and so TUPE wouldn't apply to their employment. Sometimes where there is a separate contract between the parties as part of the tender process, there can be some provisions in there which prevent a transferee offering employment to a transferor's employees ahead of the proposed TUPE transfer, so that would have to be checked. But technically, if they're not part of the organised grouping at the point of transfer, then they're not eligible to transfer under TUPE, and TUPE is kind of irrelevant to their employment. The second one we received was, is it possible under TUPE to restructure or assign different staff roles? And also change their pay or working hours? I think we might have covered this already in the webinar, but it is technically possible legally. It's complex, it's technical. You need the general starting point is that our employees are entitled to transfer on their existing terms and conditions as they benefited from immediately prior to the transfer, and any changes to those which are because of or connected with the transfer are automatically void. The main time changes can be committed if the sole or principal reason for the changes, as we said before, is for an ETO reason, so an economic, technical or organisational reason entailing a change in the workforce. And it's important that it also entails a change in the workforce. It's not sufficient to just have an ETO reason. Practically, that will normally mean where there are redundancies or a change in location of the work to be carried out. But it is a complex area and you need to get specific advice on that. And there are other circumstances where changes can be permitted, such as where the contract permits the employee to make that particular variation. As we discussed previously, generally administrative changes, nothing more severe than that. In circumstances where there's collective agreement or where the transferor is subject to insolvency proceedings, but they are the least used areas. You're generally talking about changes already permitted or changes for ETO reasons entailing a change in the workforce. Another question, how long does an employee have to work for a company to be protected under TUPE on transfer of ownership? There's no minimum service requirement to receive protection under TUPE. The usual rules around unfair dismissal still apply, however. So an employee dismissed because of the transfer can only bring a automatic unfair dismissal claim if they have 2 or more years service. The right to a protective award, though, for failure to inform and consult has no service requirement at all. Should a TUPE employee be recruited as you would a non-TUPE employee? So an employee who transfers under TUPE, as I said, is entitled to transfer on the same terms and conditions of employment as they enjoyed immediately prior to the transfer, and they maintain their continuous service from the transferor. All relevant documentation such as employee files should be sent to the transferee by the transferor once the transfer happens, as the transferor has no further right to keep hold of those. The transferring employees are therefore not recruited in the usual way, but it can sometimes be useful to meet with them soon after the transfer, discuss any missing information, check necessary documentation, generally introduce them to the transferee as their new employer. And I've had clients in the past who've used an abbreviated version of their induction process to onboard the new employees once they transferred under TUPE. How can you guarantee that the business that is transferring to you will honour all outstanding staff wages and accrued holidays? Generally speaking, under TUPE, all liabilities transfer to the transferee at the transfer date. So if the transferor has failed to pay outstanding sums from when they were transferring, when they were the employer, that liability will fall on the transferee. If an employee sues the transferee for that outstanding liability, the transferee can apply to join the transferor as a party to the claim, but as there's generally no contractual relationship between the transferee and transferor, the transferee cannot sue the transferor directly for recovery of those sums. The only time that this changes is when there is that commercial agreement between the parties, between the transferor and the client, which confirms that the transferor will be liable for any sums owing up to and including the transfer date. And then there'd be generally a separate contract between the transferee and the client, confirming that the client will indemnify the transferee for the liability of the transferor. It does leave the transferee in the unfortunate circumstance of having to sue the client, but the client would then have the same cause of action against the transferor. And then the last one that we had was, does long service pay continue or is it ceased while in the TUPE period? All contractual benefits of the transferring employees received, they received immediately prior to the transfer, must be maintained by the transferee. So long service awards would need to be continued by the transferee. And that's all the prior questions that we've got. I don't know whether you're back, Lindsay.
I am back. Can you hear me okay
now? Yes, you are. I can hear you perfectly.
Excellent. So we haven't had any further questions into the chat that I can see. Just give anyone the opportunity while we've got a few minutes left. If they want to pose a quick follow-up question, they're welcome to type that in the chat. In the meantime, thank you very much for your webinar. Brilliant, so informative, so much content in there. And everybody listening, as we've said, that these slides and this recording is available for you, so you can watch this back and continue your learning. As mentioned, there's also a flow chart. Is there anything else? With just a flow chart, I think, which will help support with this. That will be included in the email that we send out. Along with, if you would like to explore the QCS system, there'll be a link to a free trial. The reason you might like to do that, some of you on the call will be customers of ours, some of you might not be. If you are a customer of QCS, then you have access to Chris and Olivia, or after Athena, through the QCS system. You can have some free advice on HR by clicking the button within the system in the HR section. And obviously, on the back of this webinar, you have the opportunity to email us as well if you've got any further questions. You're welcome to ask us and we can answer them via email. And no further questions have come in. Oh no, there's one's just popped in. If TUPE staff have no previous contract, can we write them a new one?
Yes, and it's probably practically a good idea to do that. What you have to be conscious of, though, and this will come out through the ELI process and hopefully a further dialogue with the transferor, that new contract cannot be what you choose it to be. That new contract has to be on the terms that employee is. They are engaged on some terms, it's just that they're not written down. So those terms need to be reflected in any written document that you give them after a TUPE transfer, but it's about discovering what those written terms are prior to the TUPE transfer happening, and hopefully getting that you will get some information through the ELI on basic terms of employment, but granted, if you just get the basic ELI, you're not necessarily going to know everything. So that will either come from an open transferor who's willing to have that discussion with you, or you will have to take the employee and then work out what terms they were on prior to that with a discussion with them, which is obviously open to abuse, but it is just a practical difficulty of TUPE, unfortunately.
Okay, thank you for that, and thank you, Rebecca, for your question. So no further questions have come in, so we'll sign off. I will once again thank you for your time and your input on this webinar. Super informative, super helpful, and thank you everyone in the audience for listening. I hope you enjoyed it. Okay, take care.
Thank you very much.
Thanks a
Thank
lot.
you.
Thank you.
Bye-bye.
Bye.